Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the NPTEL online certification course titled Medical Law. As you know, we are on the third module. Last few lectures have gone through. We were discussed the week 1 as a module 1 5 lectures, week 2 as module 2 another 5 lectures. So now we are at the week 3 module 3rd. So lecture 1 of module 3rd we have covered, which was on medical negligence and medical malpractice. So today we will discuss very important landmark judgments. So myself, Dr. Chaitanya Mittal, currently working as medico legal consultant at Dr. B.C. Roy Multi-Specialty Medical Research Center, IIT Khanpur. So today we will go through the important landmark judgments on the medical negligence. So, you will come through the various judgments or the various guidelines which have come up with these judgments of the apex court on medical negligence. So, let us start with the lecture 14 of module 3rd, the important judgments. So, we will be discussing these important concepts which will be covered in this lecture. The negligence, what do we mean by negligence? General negligence, professional negligence, and then we will come to the medical negligence. The history of medical negligence, components of medical negligence, judicial approach on negligence, and what would be the defenses for the healthcare professionals or the doctors in medico legal negligence cases. So, what are the important keywords? Medical negligence, consumer rights, negligence per se, and the defense. So, we will start our lecture with the definition of negligence. So, negligence is defined as the breach of duty. Whatever the duty or person is being assigned, so any change or any breach has occurred in that duty. So, as a breach of duty resulting from the failure to take action that a prudent and reasonable man would take, or from acting in a way that a reasonable man would not act, governed by the same consideration that normally govern the human affairs. So, in a general term, act of commission or omission, जो करना था वो नहीं किया, जो कर लिया वो एक्चुअल में नहीं करना था, और जो नहीं किया वो करना था. तो ऐसा है द नेग्लिजेंस. ठीक है. सो इट्स अ ब्रीच ऑफ ड्यूटी, दैट्स अ कीवर्ड इन डिफाइन. अकॉर्डिंग टू द विनफील्ड, negligence as a tort is the breach of a legal duty to take care, which results in damage by the defendant to the plaintiff. The evolution of common law on professional negligence dates back to the first landmark case of Dongi versus Stevenson, 1932 year AC 562. So, this was the case where the very famous case on basis of law background students, that the two persons were sitting in the cafe. So, one has consumed a pint of beer in which there contains a one mosquito or an snail. Because of that, the neighboring one which is sitting aside has not even touched, not even drank anything, but he got fainted by seeing that. So, the court has given a judgment on that, that if anything happens in a room, in a cafe, to the neighboring one also, is liable to give the damages occurred to that neighboring person. So, here comes the principle of neighbor. So, this is a famous landmark case of Dongi versus Stevenson in year 1932. Then there comes as a medical negligence can be read under the ambit of professional negligence. Medical negligence is the term used when a medical professional treats a patient incorrectly or without reasonable due care and skill, carelessly or negligently. This could entail a doctor or a healthcare professional or a staff or a nurse or any surgeon, pharmacist, dentist or other member of the medical staff acting irresponsibly. Negligence is usually the cause of this departure from the minimal standard of care required of all medical professionals. The medical negligence is the primary basis for most medical negligence claims in which the plaintiff asserts they were injured as a result of medical care or treatment. When a patient gives consent to a doctor to cure him or her, the doctor is supposed to perform his or her duty with diligence, with due reasonable skill and care. For an example, if a person goes to the doctor Z, the doctor has the discretion to choose any alternate medical procedure, but if the doctor chooses a procedure and act negligently while performing the procedure, he can be liable for the negligent act. On the other hand, if the doctor were not negligent, but the procedure resulted in undesired outcome, then the doctor does not hold any liability for the patient damages occurred to him or her. So, coming to the history, how it has evolved in the medical negligence in India. In ancient India, notable works on medical science are found in many literary works such as Chak Samhita, Susruta Samhita and Vagbhata Susruta Samhita. Wrong treatment is titled Mithya and Mithyapachara under ancient Indian medical literature. Susruta Samhita acknowledged that if the death is caused by the negligent act of the doctor shall be punished severely. Also, the growth of disease due to negligent doctor should be regarded as assault or violence against the patient. So, this has been mentioned with ancient Indian medical literature, that is Susruta Samhita. So, coming to the next, Yajnavalkya Smriti also provided fines and penalties for the doctors who act negligently. So, in ancient India, so the penalty was as 1000 pana, so which are in the form of silver coins. Each coins will have approx 9.5 grams. So, as ancient India, so it was calculated in the form of grains. So, roughly approximately in modern India timing, it is an approx 9.5 grams of each silver coin. So, the 1000 pana was the penalty prescribed for medical negligence. The Kautilya's Arthashastra gave a code of ethics for doctors. If a doctor discover a dangerous disease during a patient treatment, he is obliged to notify the appropriate authority under privileged communication. It must to inform to the higher authorities or to the community that such a epidemic or endemic or pandemic disease can prevail. So, it is also necessary to inform and counsel to the patient and inform to the higher authorities. If patient dies due to the negligent act of the doctor, the highest punishment used to be inflicted. Post independence in 1956, the Indian Medical Council Act was implemented for the regulation of the conduct of doctors. Indian courts used to provide remedies in medical negligence cases through criminal law. The Indian Penal Code 1860 deals with criminal liabilities of a doctor in medical negligence. Indian courts also decided on medical negligence claims under tort for providing damages to patients or their relatives. So, you must understand the term damage and damages. Damage, the injury or the assault or battery occurs to the patient, but damages is a compensation claim. So, the word you should not get confused. So, damages means any compensation claim being provided by the healthcare professional to the patient as per said by the Indian courts. Similarly, the introduction of the Consumer Protection Act 1986, now as a latest Consumer Protection Act 2019, opened a new quasi-judicial, cheap and convenient system of redress for patients and their relatives. Indian courts also adopted the approach of foreign courts while deciding medical negligence cases. So, coming to the judicial approach to the various medical negligence cases. So, first and foremost, the famous is the Bolam's case, which gives a Bolam test. In Bolam versus France Hospital Management Committee in the year 1957, to be cited as WLR 582-586, the test for establishing medical negligence was set out. It was held that the medical practitioner is required to exercise the ordinary skill of a competent medical practitioner of his field. The doctor must exercise this ordinary skill in accordance with a skilled person in that area. A doctor cannot be held liable if there is no other possible alternative and another competent doctor would have acted in the same manner in treating the patient. So, you must understand this is a very famous the Bolam's case, which has given result into the Bolam test. So, the doctor who is performing any act in the under reasonable skill and care, so he will not be held liable. The precedent set out in the Bolam test was adopted in India by the Apex Court Supreme Court. Coming to the next, Jacob Matthew famous case. In that, Jacob Matthew versus State of India 2005-6 SCC, that is the Supreme Court cases, won as the most efficient measure of testing medical negligence, saying that by this standard a professional may be held liable for negligence on one of the two findings: either he was not possessed of the requisite skill which he professed to have possessed, or he did not exercise with reasonable competence in the given case the skill which he did possesses. So, the Jacob Matthew, the famous case, has given the two major guidelines. Another case, Jugan Khan versus State of Madhya Pradesh, All India Reporter in the year 1965, Supreme Court 831. The sole point of the case relevant to medical negligence is the distinction between the qualification of doctor, that is a homeopathy, and the prescription of medicine, Ayurvedic. The court held that the prescription of medicine was an act of negligence on the part of the doctor. Another case in Lakshman Balkrishnan Joshi versus Triambak Babu Godbole and another, ANR is another, in a year 1969 one, SCR 206 is a citation. The practitioner must bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. Neither the very highest nor a very low degree of care and competence judged in the light of the particular circumstances of each case is what the law requires. The doctor no doubt has a discretion in choosing the treatment which he proposes to give to the patient, and such discretion is relatively ampler in cases of emergency. So, the doctor should tell or inform to the patient prior that this type of treatment or this alternative is also available, but this is the best, or saying the risk and benefits of the particular treatment to the patient. But in case of emergency, he can proceed the best treatment in his reasonable skill and care. In Indian Medical Association versus VP Shantha in a year 1995, Supreme Court cases 651, the famous case Shantha with the Indian Medical Association, what the court absorbed: a patient who has been injured by an act of medical negligence has suffered in a way which is recognized by the law and by the public at large as deserving compensation. This loss may be continuing, and what may seem like an unduly large award may be little more than that sum which is required to compensate him for such matters as loss of future earnings and the future cost of medical or nursing care. To deny a legitimate claim or to restrict arbitrarily the size of an award would amount to substantial injustice. After all, there is no difference in legal theory between the plaintiff injured through medical negligence and the plaintiff injured in an industrial or motor accident. In this case, the Supreme Court decided that unequivocally medical services fall within the purview of the Consumer Protection Act 1986, which is now as 2019. So, which has changes done that still the patient or the medical services comes under the purview of Consumer Protection Act if any amount or the cost is involved. In case of free cost of treatment, so does not come under the purview of Consumer Forum. So, next judgment, Achitra Haribhav Khodwa versus State of Maharashtra and others, ORS is others, in a year 1996 to Supreme Court cases 634. In this case, the court held negligence is writ large. The facts as found by both the courts in a nutshell are that Chandrika Bai was admitted to the government hospital where she delivered a child. She had a sterilization operation afterwards. This operation is not known to be serious in nature and was performed under local anesthesia. Complication arose thereafter which resulted in a second operation being performed. She did not survive for long and died. Both doctors have stated that the cause of death was peritonitis, that is a inflammation or infection of peritoneum. In this case, the Supreme Court applied the doctrine of res ipsa loquitur, the facts or the things which speaks itself. It is a crystal clear, the layman can understand it is a case of negligence. So, in the next case, in the case of Poonam Verma versus Ashwin Patel and others in a year 1996, Supreme Court cases 332 says negligence per se, which is a sort of negligence apparent on the face of the record. When a homeopathic doctor prescribes allopathic medicine, the court held it was deemed to be negligence per se. How can a homeopathic doctor can prescribe a allopathic? It is a clearly a negligence. Even layman, even very poor man can also says that how a homeopathic doctor can give an allopathic medicines. He must give only the medicine belongs to his expertise. Where a person is guilty of negligence per se, no further proof is needed. The Supreme Court, the apex court observed that the negligence has many manifestations. It may be active negligence, collateral negligence, comparative negligence, concurrent negligence, continued negligence, criminal negligence, gross negligence, hazardous negligence, active and passive negligence, willful or reckless negligence or negligence per se. So, there are many different types of, because of the different case scenarios, the Supreme Court has observed so many manifestation in case of negligence as well as in case of medical negligence. Negligence per se, what do you mean by it? The conduct whether of action or omission, the act, commission or omission, which may be declared and treated as negligence without any argument or proof as to a particular surrounding circumstances, either because it is in violation of a statute or valid municipal ordinance, or because it is so palpably opposed to the dictates of common prudence that it can be said without hesitation or doubt that no careful person would have been guilty of it. As a general rule, the violation of a public duty enjoined by law for the protection of a person or property so constitutes. So, negligence per se जो दिख रहा है सामने ही बिल्कुल द नेग्लिजेंस, ये क्लियर कट नेग्लिजेंस है, ये गलती है, ये होना ही नहीं चाहिए था या ऐसा करना चाहिए था. द लेमैन एक आम आदमी बता सकता है कि ये नेग्लिजेंस है. दैट इज द नेग्लिजेंस पर से. In the case of Miss Spring Meadows Hospital and another versus Harjol Ahluwalia in a year 1998, Supreme Court cases 39. The question was, if the child was a patient, then can parents and the child be consumers, and can damages be awarded in favor of parents as separate from those awarded to the child as a mental agony which the parents has suffered due to the damages has occurred to the patient, that is a child. So, both child and parents are deemed to be the consumer within the meaning of Consumer Protection Act 2019 as well as 1986. Supreme Court held that Consumer Commission may award damages for the mental agony of the consumer that is being faced to the parents as well as the patient himself or herself, that is being the child. So, coming to the next judgment, the state of Haryana versus Srimati Santra in a year 2000, Supreme Court cases 182, was the case pertaining to the medical negligence per se. The Supreme Court held the state government and the hospital vicariously liable for the child born out of a negligent sterilization procedure. So, the higher authority, that is the hospital, being the vicarious liable or found to be guilty for the negligence happened in the hospital. Next, the Vinita Ashok versus Lakshmi Hospital and others, All India reported 2001 SC 3914. In this case, the apex court undertook the precedent of the Bolam case, as we did not examine the medical practice at the time of the event and not from the future position in the practice. Doctor cannot held negligent for not choosing a procedure that was not available at the time of procedure, but developed in the future. So, whatever being the procedure available or under his reasonable skill and care, only that doctor can choose. He can't choose to the higher advanced technology which has come now, not at the time during the incident has happened or during at the time of operation. The claim was dismissed by the apex court. In next case, in the Srimati Savita Garg versus the Director National Heart Institute in a year 2004, Supreme Court cases 56. The Supreme Court overturned the decision of the Commission which dismissed the petition of the claimant for non-joinder of the necessary parties in the claim and observed that the complainant may not have knowledge about the specific doctors or medical staff involved in the treatment. Thus, the burden of proof is not on the complainant, but on the hospital or on the person who is negligent or the accused once the patient shows prima facie negligence. This case allows for setting aside the technicalities of procedure law in favor of substantive law, since medical negligence came within the purview of the consumer disputes redressal form. This is a less of a problem. In another case, Dr. Suresh Gupta versus Government of NCT, that is National Capital Territory, Delhi, and another in a year 2004, Supreme Court cases 422, wherein it was held that the bona fide medical practitioner should not be put through unnecessary harassment. The court observed that doctor would not be able to save lives if they were to tremble with the fear of facing criminal prosecutions. In such a case, a doctor may leave a terminally ill patient to his own fate in an emergency where the chances of success may be 10% rather than taking the risk of making a last ditch effort towards saving the subject and facing criminal prosecution if the effort fails. The court held that a simple lack of care, error of judgment or an accident is not proof of negligence on the part of a medical professional, and that failure to use special or extraordinary precautions that might have prevented a particular incident cannot be the standard for judging alleged medical negligence. The concept of medical negligence was further analyzed, throwing light on the judgment held by the apex court in Jacob Matthews versus State of Punjab and another in a year 2005 Supreme Court cases 1. In this case, it was held that mere deviation from normal professional practice is not necessarily evidence of medical negligence. Simply because a patient has not favorably responded to a treatment given by a physician or a surgery has failed. The doctor cannot be held liable per se by applying the doctrine of res ipsa loquitur, that is the things which speaks itself. The Supreme Court also provided some guidelines prosecuting medical professionals for medical negligence. A private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor. The investigating officer should, before proceeding against the doctor accused of rash or negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in government service. A doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been levelled against him, unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied. So, in the case of State of Punjab versus Shivram and others in a year 2005 Supreme Court cases 1, the Supreme Court differentiates between negligence and accident. The court held that merely because a woman have undergone a sterilization operation, became pregnant and delivering a child, the operating surgeon or his employer cannot be held liable if he has not acted negligently for compensation on account of unwanted pregnancy or unwanted child. So, the must is the doctor should not act negligently or should have performed the operation with a reasonable skill and care. It has happened due to an accident or mishap. So, in that case the healthcare professional is not held liable. The case of Nizam's Institute of Medical Science versus Prashant S. Dhanaka, All India Report in the year 2009, Supreme Court 1503, focused on the various stages of medical negligence. The court provided an emphasis on the stages of negligence that are the preoperative, operative as well as the postoperative cases. It was held that there was preoperative negligence in not determining the true extent of the tumor and its extension into the spinal cord by undertaking proper tests available in the hospital itself. So, the another case, the Dr. Balram Prasad versus Dr. Kunal Saha, very famous case, Kunal Saha's case and others in a year 2014 Supreme Court cases 384, provides guidance on the compensation in the cases of medical negligence. In this case, the court relied on various judgments and reiterated the principle that there is no restriction on the amount of compensation that could be awarded in medical negligence claims. In an appropriate case, a court or tribunal, if satisfied, may pass the enhanced award. The only embargo is that it should be just compensation. So, the recent judicial trends in medical negligence claims are: it was decided in Sanjay Ambastha versus State of Chhattisgarh through the Secretary Health and Family Welfare Department in a year 2021 that during the chaotic situation amidst the ongoing COVID-19 pandemic, medical professionals have put themselves through unprecedented difficulties in treating and serving patients. It is not appropriate to accuse these doctors of medical negligence for decisions they make as last resort to save patients' lives. So, the latest development which happened on the medical negligence, it has been more than 17 years since the Supreme Court for the first time in the Jacob Matthew case in 2005 directed the center to frame statutory rules in consultation with the Medical Education Regulator Medical Council of India, now as National Medical Commission NMC, to deal with the medical negligence cases as it impacts both doctors as well as the patients and even their relatives. Although the Supreme Court time to time provided directions to the central government to frame dedicated regulation, government is reluctant to take the issues at hand since long back. While people must pursue legal action against negligent doctors, medical professionals are harassed by baseless accusation and malicious lawsuits. Legal and healthcare providers agree that an effective legal structure will prevent violence against doctors while safeguarding patients' interests. Though there is no guideline at present, the matter is under consideration. The Union Ministry of Health and Family Welfare has taken the healthcare sector's long-standing demand to frame guidelines for determining medical negligence cases into consideration. So, coming to the conclusion of this lecture about the various judgments which have come to the various guidelines on the medical negligence. So, after studying the various judgments, we can firmly say that Indian courts undertook multi-dimensional aspects of the medical profession. The definition of a professional is someone who possessed the required training and experience. If we continue to label every small error of a doctor as a result of negligence requiring him to pay damages, it will restrict his ability to practice medicine as he thinks proper. Furthermore, there is always some degree of ambiguity in any field, but especially in medicine. Therefore, it would not be appropriate to accuse someone of negligence, especially when that career deals with something as complicated as a human body. It is a responsibility of doctors and legal professionals to educate people so as to prevent the cases of medical negligence rather than resolve them through lengthy legal processes. So, it has to understand in both the ways, either the doctor, in law enforcement agencies and the public, to understand that the treatment done by the doctors are with reasonable skill and care. Unless if they does so any criminal negligence or the gross negligence, definitely the doctors will be held liable. Otherwise, for a small things, that should not be create any issue and resolve it in the matter properly. So, these are the references. We have gone through the various judgments. You can also check for further readings. There is a medical law book of a year 1996, year 2016, one of the article retrieved from the Journal of Medical Ethics, another the Supreme Court on Medical Negligence of year 2006, and another website which I have gone through as a Union Health Ministry. So, you all students can go through these references for further understanding of the various judgments on medical negligence. Thank you very much.